in the country. As a bilateral chamber, we also facilitate business-business relationships between Luxembourg and Ireland. The conference Saint-Yves is the oldest law society in Luxembourg. This afternoon's event will be an open legal discussion on fund vehicles with an emphasis on the Luxembourg and Irish partnership options. I would like to introduce you to William Simpson, who is the president of the conference Saint-Yves, and he will guide us through the agenda and introduce the speakers. In the meantime, we look forward to an interesting exchange of information and opinion, and to learning a lot more about the future holds for both the Irish and the Luxembourg partnership fund vehicles. William.
Thank you very much. Dear audience, dear speakers, as you may have noticed, we have chosen a challenging title for today's conference. Will the Luxembourg partnerships survive? She is head of the BSP Investment Management Department, and her dual Luxembourg-Irish background will be of high value this evening. And last, Oisín Kingallen, our only non-legal speaker, but he did study some law at DCU, Dublin City University. Oisín has worked in the financial industry in Dublin and in Luxembourg. He is currently VP with Brown Brothers Homan in Luxembourg and specialized in the alternatives. The discussion of this afternoon will be divided in 3 parts. First, Edouard will explain to the audience how to articulate tax, corporate, products, and regulatory laws and requirements when setting up a fund. The use and the future of the fund vehicles toolbox will then be described and discussed with Sebastiaan. Second, Edouard will explain the development of the Luxembourg partnerships. Evelyn will then broaden the subject by presenting other partnership solutions, and notably Irish partnerships. Third, Oisín will then explain the limitations and solutions offered by the Luxembourg and Irish partnerships, which will enable to initiate a conversation with the other speakers. The guiding principle of this afternoon's event, which is also the motto of Saint-Yves, is to bring clarity on complex legal issues. I really hope that in 1 hour's time, you will have all the relevant tools to understand the current challenges behind the fund partnerships. 3 material points: certificates. We will provide you with certificates of attendance. If you send an email at the end of the conference, marketing@bsp.lu, we will have a way to see if you have followed the whole conference, and we will then issue the certificates. Another point, the conference is also available on YouTube, and a transcription of the conference will be provided in several weeks. Final point, you can ask questions on the column Q&A, where you can insert a few questions. We will see them. I wanted to thank our speakers, the Ireland-Luxembourg Chamber of Commerce, the law firm BSP, and the staff for all the good and great work to prepare this event. Edouard, the floor is yours.
Well, thank you, William, and thank you for giving me the opportunity to. No one wants to get COVID from me, so I will just take that out for this conference. Thank you for giving me the opportunity to talk about all these topics regarding Luxembourg funds and the Luxembourg Fund Toolbox and the Luxembourg Partnership, and also for giving me the opportunity to wear a tie for the first time for more than 1 year. So thank you. Maybe a few words of background. Luxembourg represents more than 5 trillion euros of assets under management in Luxembourg, regulated Luxembourg fund structure, which is quite a huge amount. And if you add to this 5 trillion the non-regulated fund structure, we are above 8 trillion euros, which makes Luxembourg the second largest financial center in the world and the first one in Europe. Where does this success come from? The success comes from the Luxembourg fund model, which has been articulated around 3 pillars. The first one relates to the GPs, the fund managers. They are offered structuring flexibility. Laws in Luxembourg and always try to give to the greatest extent possible flexibility options to the fund manager to enable us to structure investment solutions that helps them to have product that fits the need of specific industries they are acting in. It could be private equity, infrastructure, hedge funds, and so on. Second, investor protection. If you offer flexibility to fund manager, you also need to ensure that the right of investors are protected. And that also a significant part of the Luxembourg model, with the key role of the Luxembourg regulator in this structure and its authority, so the CSY. And finally, going through Luxembourg would not have been accepted if there would have been severe tax leakage by using Luxembourg fund structure. And that's why the entire purpose of the Luxembourg legal and tax framework is to offer tax neutrality to investors and to fund managers, but in particular to investors, trying to make sure that they would be, in an ideal world, in the same situation as if they were invested directly into the underlying asset, even though they invest through them. So that's basically the 3 pillars that have governed the entire Luxembourg legislation regarding funds, and that's why we are going to try to demystify now, because sometimes there are a lot of acronyms with that everyone has difficulties to understand, or concepts that need to be mixed together in order to create a fund structure. But you will see there is a very simple recipe to cook a Luxembourg fund. This recipe, that's like a burger. The key element you have to take into account to create a fund is first the tax requirement. Do I want a tax opaque or a tax transparent structure? Well, taxpayer in Luxembourg to benefit directly from double taxation treaty. Do I want tax transparent entity to be, well, in this case, completely neutral? Once you know whether you need a tax opaque or a tax transparent structure, then you can start to determine the legal form of your fund. You can go for a corporation, and then you will have more tax opaque structure, like the public, private limited companies, the corporate partnership limited by shares. You can also go for other partnership structure, like the 2 limited partnerships we have in Luxembourg, and we will detail a little bit later today, which are the special and the common limited partnership. And finally, if you don't want Luxembourg body, then you can always go for a contractual form for your fund. That's the common. I'm just looking here about alternative because that's really the key topic of this day. So I'm not discussing at all the UCITS, which are the funds dedicated more to retail investors. So that's why for alternative funds, you will find basically once the next level or next layer of your burger, which is the product law. What is that product law? That's specific legislation body, which gives some advantages to make sure that the form you have chosen for the fund, which is the basic form, has the necessary flexibility to work as a fund. It goes for structuring flexibility and also for necessary tax regime that will enable us to have our tax neutrality, and will also add on those regimes the supervision of the CSSF to make sure that the investors benefit from a certain level of protection. So-called product laws are the laws on specialized investment fund, the law on the investment company in risk capital, CCAR, and more recently, and we'll see how, the reserve alternative investment fund, which is not directly regulated by the CSSF, but indirectly through the last layer of regulation or justice. These product laws, and only those product laws, give you the possibility to have compartments, to have variable share capital, which are really the toppings of your burger. Once you've gone through all these steps, so from the basis of the burger until the specialties you need, then you will have to consider whether you fall within or whether you want to fall within the AIFMD regime. AIFMD stands for Alternative Investment Fund Manager Directive, which is legislation that governs the manager of the fund and that obliges the manager to make sure that all the funds it manages meets a certain number of criteria. Some SIFs, for instance, which are under the product law, may fall within the scope of the AIFMD, some others may not. So that's why it's like any burger. If you can always stop to eat your burger at any time. You're not obliged to eat the top together with the rest of the burger. At the end of the day, you come to some kind of a pyramid of where you can look at the regulatory weight and the structuring flexibility, and you see that some products are much more regulated and less flexible than others. And if we start with the CCAR, it's because they are only authorized to invest into risk capital investments, and they are under the control of the CSSF. And then we go up to the partnership, which is completely free in terms of organization. Everything will be in the limited partnership agreement, and it can be or not under the supervision of a regulator. And in between, we have all the range of products we have the Luxembourg Toolbox offers. So maybe now we can focus on the limited partnership. So the idea, I will not go through all the details of the partnership structure because it's everything in the slides. And we will have, do we share the slides afterwards with the? We can. Yeah, okay. Otherwise, I will just you can have a look at the slide. I will just focus on the main topics. But before that, maybe you want to talk about the Luxembourg Toolbox as well.
If you
I think
want to,
makes sense that we.
If it fits well in your speech, that would be good, maybe.
Yeah.
Thank you very much, Edouard, for providing an overview of the Luxembourg Toolbox. With almost 8 trillion AUM or even more, it's not easy to challenge how the toolbox could be better, with having a financial domain, which is the second biggest center in investment funds in the world. But I try to do my best to take away the cheese from the hamburger, at least as it concerns toolbox. I mean, if we look from a financial regulatory perspective on European level, we don't really see anything with respect to products or legal forms. And the reason for that is that the European legislator considers that fund managers have to be subject to conduct of business rules, prudential law, depositories basically the same, and that legal forms have a very marginal role in fund governance, at least if you look at it from a financial regulatory perspective. Actually, they only have two roles. In the first place, they provide limited liability for investors, and in the second place, they ensure that there is a segregated asset patrimony, so that the assets of the individual investors are not being commingled with fund managers or with the depository or between the investors itself. So due to this reason and due to this adaptation to fund governance, more and more countries have in the past few years, especially after the adoption of the AFMD, adapted their legal forms to a larger extent to fund governance. Luxembourg has also done that with its Scsp and SES. The claim I want to make is that it would maybe be an improvement to shift the legal forms in Luxembourg from the product laws to the AFM law. And the reason for that is that there are basically three arguments for that. In the first place, if you look at the legal forms, you see in every single product law like the similar type of legal forms that are being available, and it creates some confusion. In the first place, not every legal form is being available in every single product law. But if you consider that from an investor protection and market protection standpoint, legal forms which provide these two features of limited liability and segregated asset patrimony, then it would actually not matter what legal form you would apply in what product law. In the second place, there are also inconsistencies to be found. One notable example, maybe not a product law, but in Luxembourg corporate law, you cannot employ any umbrella structure. Whereas from an investor protection standpoint, actually it makes no sense to differentiate between, at the one hand, product laws in which you have AIFs as SCSPs or SCS, and at the other hand, it being established under Luxembourg corporate law. But the most important reason why I would claim for a more product law neutral regulation of the legal forms and to regulate all legal forms from the product law into the AFM law is the overlap with EU product laws. Now we have VECA, EUSEF, money market fund regulation. Till now, it is not that yet so often used because Luxembourg products often are more efficient, or in the case of money market fund regulation, it is mandatory, but they're more efficient. But there's now an ongoing tendency to claim that LTIF might become the third pillar amongst UCITS and the AFMD. And if that is really going to be the case, if the LTIF regulation is going to be amended to be truly a retail product for alternatives with a passport, you would not apply a product neutral approach with legal forms, then basically there would be an overlap between, at the one hand, having to structure your legal form also for tax reasons through a product law, and at the other hand, then having to apply the mandatory heavy requirements of LTIF, which are to be expected. The same holds true for loan origination and loan participation funds. There's already discussion going on for 5 years how to regulate this, but I know that the Commission is busy with it. And if you would not apply a product law neutral approach with legal forms, then there might also be overlap into this. So coming to a conclusion, I think the Luxembourg Toolbox is obviously very flexible and obviously one of the most flexible regimes in Europe. But I think it could be a bit better if a more product law neutral approach would be applied. Thank you very much.
So thank you, Sebastiaan, for sharing your very interesting views on this. If I do properly understand, to sum up, your proposal is just to because you've all noted that the Luxembourg Toolbox works like a burger, of course, but also like Lego blocks, and you can mix all of them, take some of them, take out some of them to replace them by others. And your idea or your proposal would be to maybe exchange the way we build the Lego and exchange the blocks and build them differently than what we do today. So that's a very interesting view. And it makes a perfect transition to talk about a legal form on which we can add product laws regulation and AFMD regulation as well, which is the Luxembourg limited partnership, and then compare it with the Irish limited partnership. Thank you. So that's exactly what I was trying to do. I was a bit too fast. So I'm just back to what I said. I won't go through all the features of the limited partnership. The idea is more to pick some of them to give some flavor of what the main features are in order to be able to compare those features with the Irish limited partnership. And for this, I would just start to say that I will just focus on the limited partnership as we know it, and that we name special limited partnership and common limited partnership. So I already exclude the corporate partnership, the société en commandite par action, which is more a corporate body. So here the purpose will be dedicated to the partnership. There are two flavors of limited partnership in Luxembourg. We have, on the one hand, the special limited partnership, on the other hand, the common limited partnership. Oh, sorry for that. The common limited partnership is one of the oldest legal form we have to create a company in Luxembourg. But it was not that many used in the past. And the reason for that is mostly that all the limited partner, the name of all limited partner had to be disclosed. So there were very few common limited partnerships being created before 2013, the date on which the Luxembourg Parliament decided to revise and revisit entirely the limited partnership regime. Sorry for that. I thought it was normally. Yes, let's go. Sorry, it's a new one, and I thought I turned on the phone. So it was entirely revisited in 2013, when the legal framework of the special limited partnership was created. We have those two legal frameworks because we noticed that some jurisdictions are pretty used to entities or partnership with legal personalities, like the Jersey limited partnership, and some other are used to entities that do not have a legal personality, like the UK limited partnership. So we basically, as that's the Luxembourg pragmatic approach, we decided to take the best of the two legal regimes to try to create our own partnership. It's been quite successful because there is more than since the inception of the Luxembourg partnership, there is more than 1,200 partnerships that has been created. So during a certain period of time, there was more than one partnership created every single day in Luxembourg. And I'm just talking about the special limited partnership. So then if you have the common limited partnership, that's even more than that. So I said we have this dual regime, the common limited partnership with legal personality and the special limited partnership without legal personality. I will mostly focus on the special limited partnership today because that's the one that is widely used in the fund environments in our industry, even though we also see common limited partnership. But let's focus on the more standard. So the starting point is that this is a completely free legal regime, meaning that there is no mandatory rule in the law, or very few mandatory rules in the law. The law of 1915 on companies in Luxembourg only foresees a default regime, meaning that if you forget to give you some rules through the limited partnership agreement, which is the founding documentation of the limited partnership, then you have default rules in the law that will apply. Most of the time, you are free to set whatever rules you want, and the partners are really free to organize among themselves as they wish. That's a true partnership. So the special limited partnership, as opposed to the common limited partnership, does not have any legal personality. That's the key criteria between the two forms. Despite that, the law clearly says that all inscription and ownership rights belong to the partnership as such, even though it does not have any legal personality, which creates a really truly ring-fence structure, meaning that the creditors of the partner do not have access to the portfolio of the partnership, and the other way around, the creditors of the partnership do not have recourse against the limited partners in the partnership. Limited partners have, as a principle, their liability limited to their commitment to the partnership. There are very few mandatory rules. I will maybe give you one pitfall which has to be avoided. The limited partnership agreement has to be signed in two originals. That's the only cause of nullity in the law. So if you have one thing to remember, don't forget to sign it into originals. Now touching the governance of the partnership. The partnership, limited partnership, is managed by its manager. This manager can be the general partner, but it may very well be another entity that is designated as a manager and which is responsible as a director in a company. So it does not incur the same unlimited liability. So don't be afraid if one day you see a general partner that has it's a limited liability, but absolutely no management power in this. Also, the limited partner must not be involved in the management of the fund, which means that they shall not be involved in the external management towards third parties. So as such, the limited partnership may very well be involved in the internal management of the partnership, which is, for instance, and that's example given by law, the participation to committees like an advisory committee, an investment committee, or the participation to general meeting of shareholders, which was not that clear before the reform of 2013. There you go. Just checking if I forget something. No, I think that's it. So all the rules are reflected in the limited partnership agreement, and that's where you will find all arrangements between the partners, how partners are admitted, how they can withdraw from the partnership, the right they get in this partnership. So, for instance, whether they have a capital account in the partnership, or whether they receive units in exchange of their subscription in the limited partnership. Everything will be governed by these documents. Same thing for voting requirements. So the law is there is absolutely no requirement. There are very few limited topics which are listed in the law and that requires the approval or the consultation of the limited partners. But the law does not even set any majority to approve those changes. So that's, for instance, the change of the corporate purpose of the partnership, the change of nationality of the partnership. These decisions require the approval of the limited partner, but there is no majority. So you're free to set the rule you want. In the special limited partnership, finally, the limited partner, as said, they are very little involved in the management of the fund, and they do not even approve the annual account. That's not mandatory. So they will receive the annual report. There is one, but they do not have to approve it. It's all in the end of the manager, which can be the general. Finally, so if we look at a typical limited partnership structure, so in a fund environment, we see that we have our investors coming into the limited partnership, and then the partnership will invest into its investment. Here, there is one topic to which we should pay attention, which is the tax regime, because there have been some changes in the tax regulation, in particular under the anti-tax avoidance directive and the introduction of the rules on the mismatched hybrid rules. So basically, you have to analyze the structure of your partnership as from the moment you have an entity is a corporate entity interposed between the partnership and the underlying assets, and that is obviously financed through debt instruments. And your investors represent more. One of your investors represent more than 10% of the capital of your partnership. In this case, you should start considering whether you have to dig into this anti-hybrid mismatch, and I'm happy to discuss that further, but I don't want to enter into this pretty typical topic. Maybe one last thing to remember, which is important when the fund is structured, the general partner, if it is also the manager, must at any time hold less than 5% in interest of the partnership, otherwise the partnership would lose its tax transparency. That's pretty much it. That's a good basis now to compare the Luxembourg partnership with the Irish limited partnership.
Thank you. So I'm just going to give an overview of some of the main related to the Irish limited partnerships. So there are two types of limited partnership that can be established under Irish law. The regulated vehicle, the investment limited partnership, and the unregulated partnership under the 1907 Limited Partnership Act. The investment limited partnership is probably more well known as it's been updated recently. So the investment limited partnership is an AIF vehicle. It's authorised and regulated by the Central Bank of Ireland pursuant to the Investment Limited Partnerships Act 1994, which was, as I just said, amended in 2020. And that amendment basically modernised the partnership to make it to make a better framework basically for private equity type funds in Ireland. The investment limited partnership is established by means of a partnership agreement, very similar to our common limited partnership and special limited partnership. There has to be at least one general partner and one limited partner. It mandatorily has to have a depository, and it is subject to the authorisation requirements of the Central Bank of Ireland. And those requirements can differ depending on whether the investment limited partnership is to be made available to retail investors or to qualified investors. It has no separate legal personality. It has to act through its general partner. It's a tax transparent vehicle. The general partner has unlimited liability, so very similar to our partnerships here. The liability of the limited partners is limited to the amount that's contributed to the partnership, and that can be contributed in cash or property. Services cannot be used to meet these contribution requirements, nor can loan commitments. There is a prohibition on limited partners taking part in the management of the partnership. If they do take part in the management of the partnership, same as here, they risk to lose their limited liability. The Act, though, does set out a list of safe harbour provisions. So, for example, being an employee of the general partner, being on the board of the general partner, acting in an advisory committee, or exercising roles as a limited partner, none of those would involve the limited partner risking to lose its limited liability. The investment limited partnership has to have as its principal business the investment of its funds and property, so there is a restriction on its purpose. It can be set up as an umbrella fund, so with separate compartments or sub-funds. A couple of interesting points on the investment limited partnership is that it can have a dual name, so you set it up in Ireland with its normal name, and then you can register it in another jurisdiction, for example, China, with a Chinese name, using the characters of the Chinese alphabets. So that could be interesting from a marketing perspective. There's an automatic vesting of rights and obligations upon change of the general partner. So if a general partner leaves, the incoming general partner automatically takes over the rights and obligations of that general partner. And the Act also contains provisions to facilitate the migration of investment limited partners in and out of Ireland. On the downside, it is always subject to the authorisation of the Central Bank of Ireland. And as a result of that authorisation process, it does not have the same flexibility as the unregulated common limited partnership and special limited partnership here in Luxembourg. Then moving on to the 1907 limited partnership. This is an unregulated limited partnership formed under the Limited Partnerships Act 1907, which is a piece of legislation that predates Ireland's independence from the UK. So the UK limited liability partnership is based on very similar legislation, but the UK partnership has been modernised, whereas this one hasn't been, at least not in recent times. It's formed by limited partnership agreements. You have to have at least one general partner and one limited partner, and then it's registered with the company's registration office, which is equivalent to the registration here with the RCS. It doesn't have a separate legal personality. It's tax transparent. general partner has unlimited liability, and the liability of limited partners is limited to the amount contributed. There is a prohibition on limited partners taking part in the management of the partnership, but unlike the investment limited partnership, there is no safe harbor provision from the Act. They can be contractually agreed with the LPA, but if there's no conflict there in the same way as you have it for the investment limited partnership or the SCP. There's no restriction on its purpose or object, and it's not subject to any investment limitation since it's not a regulated vehicle. Neither is there possibility to set it up as an umbrella structure. There is a limit to the number of partners, and that limit is 20 limited partners, though for certain vehicles that can be raised to 50. The names of all the limited partners are registered and technically publicly available at the company's registration office. There's no possibility for limited partners to draw out or receive back their limited partner contributions without being liable for the amount drawn out. So funding is often by way of loan commitments rather than all by equity in these type of partnerships. This is a very old piece of legislation. It has been recognised that it is in need of update if it's to meet the requirements of a modern fund industry. And the Department of Business, Enterprise and Innovation, they did start a consultation back in 2019. That's still ongoing, but I think we can expect in due course that partnership structure will be modernised. Some of the disadvantages, which I already said, the limit to the number of investors. I said 20 limited partners is the normal maximum that you can have in this 2007 limited partnership. The information on the limited partners is publicly available. The redemption rights are restricted, and generally speaking, the partnership under this form, under this act, is less adapted to modern needs. That's basically an overview of the Irish partnerships. So, very much.
Maybe one question, Evelyn, if I may. So you just mentioned this new Irish limited partnership, and I mean, it's very interesting because it looks very similar to the Luxembourg special limited partnership actually. In Luxembourg, we have the possibility to qualify this partnership as an AIF, to managed by an AIFM and benefit from the European Marketing Passport and so on. Would it also apply to the Irish limited partnership, and to what extent?
The investment limited partnership is a regulated entity, and it can be, it's an AIF. It can be managed by an AIFM, be it registered or an authorized AIFM. So for me, it's similar to say one of RSCS or RSCSP going to the CSF and being approved as a SIF or a SICR.
Okay, thank you for that. It's very interesting. It makes it very interesting because it's we very often heard in the past that there was a true need for an Irish limited partnership, and in Luxembourg we were very happy with our partnership and the fact that Ireland was taking so much time to adopt its law on limited partnership, and that give me the opportunity to ask some question to Oisin, who is the one of these specialists in this implementation of Irish limited partnership, and was a very clear view on of how it is approved and tested by the market at this stage, and to which extent it is already approved and tested by the market. And maybe the first question that pops up to my mind, hearing what you've just explained and knowing what we know on the partnership, is what would be the place of this new Luxembourg partnership in the market? Would you see it more like for regulated activities, non-regulated activities? What's the advantage of Ireland, and what is the class of assets where you would see limited partnership, Irish limited partnership, being very used?
Yeah, sure. No, and I think before we dive into that, it's probably good to take a little step back here and look at what Ireland were trying to achieve amending this law. So, prior to this amendment, with the partnership that was there really was a hard barrier there. So when you had a manager that was looking at a limited partnership structure in Europe, Luxembourg was the default because there was nothing really that could compete in Ireland, which is the next big fund domicile. So the removal of this hard barrier has kind of opened up the Irish market to an extent and opened up the options for managers and has kind of put it down now to softer options that are out there. And they can be little things that we might think about. So, you know, it could be familiarity with the Irish market already for particularly US and UK managers. There's the cultural alignment. You know, if you look at the cultural alignment between Ireland and the US, you know, the US president is pretty much Irish, so it's, you know, it's never been stronger. But then there's even the smaller items that you see managers when they're kind of looking at making these decisions. Direct flights between Ireland and Luxembourg, or Ireland and the US. We don't have that in Luxembourg. There was an argument I heard recently. There's more public holidays in Luxembourg versus Ireland, and you know that's a potential barrier. But Ireland, in removing these barriers, or this barrier, the hard barrier, they've kind of gone halfway in terms of competing with Luxembourg, if you want, in this area. And they've got themselves to an extent that, yes, we can now have a partnership, but it is capped at a regulated structure. And you know, we hear that there is a 24-hour turnaround, and you know, when you have your ducks in a row, if you want, or when everything ticks the box, we have a 24-hour turnaround. But is that always going to be the case? So if you look at a Luxembourg limited partnership where you might have non-Lux directors, you might have the manager themselves, their first time in Europe, wanting to set up a structure, and they want to have a director in place on it. That director in Ireland will have to go through the CBI's fitness and probity test. In Luxembourg, because these are unregulated, we don't have the same level of scrutiny. The same with if you want to set up anything that's slightly unusual, and Ireland categorises property funds, for instance, they sit into the unusual space, if you want, in that there's pre-approval required for certain funds. So not all of them are going to fit into this 24-hour turnaround. So the Irish Limited Partnership has brought Ireland into a nice space in the sense of private equity, infrastructure, areas that you know, Luxembourg has done quite well in. But you know, one of the figures you mentioned at the start, we're 5 billion in Luxembourg with 3 billion in unregulated, and that 3 billion we think it's 3 billion, but it's actually quite hard to quantify. So the 3 billion that's made Luxembourg quite successful there, or 3 trillion, sorry, that Luxembourg has been quite successful with. Ireland at the moment still doesn't have something that can compete with that. And you know, Evelyn touched on 1907. I think the 1907, I've heard, and I'm in a room full of lawyers. Lawyers are great at finding solutions to problems. There is lawyers that are looking at how can we make this work without maybe any amendments to legislation. But I still think it's a long way away from something that will truly work. And the Scsp is still the leader in this space for unregulated structures.
Talking about the leader in the structure and for this type of structure, how the Irish limited partnership has been accepted and used by the market at this stage. I know it's a fairly new product, but do you have already a view on that? Yes.
So you know, the industry has been looking at this for a couple of years. The amendments are not something that happened overnight, and I think a lot of managers have been waiting to see how this will play out. I know one of the big four in Dublin, they did a survey of all of their clients, and I think they came up with a figure of 150 asset managers that they spoke to that said, you know, with these amendments, we will look at launching a product. I think that 150 is something like 15% of the managers that use Ireland. Irish funds themselves, they're looking to try bring in 20 billion a year is the figure that they think that this amendment can bring in. That's fairly optimistic numbers. But if you look at to date, so we've gone from, prior to this amendment, 6 regulated limited partnership funds in Ireland. We now have 7. So we've 1 that's been approved since the amendment. From talking to different industry folk in Ireland, there's another 3, I believe, that are kind of going through the initial approvals process, if you want, with the CBI in Ireland, with the Central Bank of Ireland. And there's another, I believe, 10 or so that are kind of in flight, if you want. So there has been a bit of takeoff, but compared, and maybe it's not fully comparable, but the RAIF in its first 6 months, I think there was 46 RAIFs launched. I think we're now well over the 1,000. So is it, and I know it's not fully comparable, it's kind of legal structure versus product, but if you kind of look at that dynamic and how that took off, and the RAIF is, Edouard, we were talking about earlier on, most conversations in Luxembourg started at SCSP, maybe go up to a RAIF, or maybe started a RAIF, and kind of that's where they'll sit. But is the limited partnership going to have the same takeoff in Ireland? I don't really think so, but it's, there definitely is interest there, and I do think Luxembourg has to keep an eye on what's going on there. And maybe it's a good thing. Maybe the limited partnership is going to help keep Luxembourg honest, because it's like I said at the start. To date, it's been, well, if you want to set up a limited partnership fund, you got to come to Luxembourg. Now that's changed.
That's very interesting. In particular, when if you compare the as you mentioned, the launching of the partnership, and you compare it to the RAIF. The RAIF started fairly quickly, but still it took the RAIF around 6 months, more or less, or even more, just to find its place within the Luxembourg Toolbox. People being used to the regulated structure, the other being used to the partnership, and in between we have this type of funny animal. And now I think that it's pretty clear how all these products have their place and their role to play within the toolbox, and that created a real interest for the RAIF, and I don't know is for how it will be for Ireland, but here we see nowadays more and more interest coming back for RAIFs, in particular for corporate partnership, because of the tax issues I mentioned earlier, where we need a fully taxable entity to set up the fund. So we see that in Luxembourg we have our 3 partnership structure now: the corporate partnership, and our 2 limited partnerships. So I think we developed in Luxembourg quite a significant expertise. Even though when I go to England, they just laugh at me and say, "Hey, guys, it's just 7 years down the road." Whereas for us, we've been using that for hundreds of years. So well. But still, I think we developed the marketplace as such developed a certain expertise. How did Ireland, and maybe you can give us some tricks or secrets here, how did Ireland took the Luxembourg expertise into account when designing its framework? Because we see from your your presentation that they very look like twin brothers.
Yeah, I think, I mentioned Ireland have been working on this for quite some time, so they've probably had the advantage of being able to almost steal Luxembourg's homework, in the sense that they've been able to take what's worked here and try replicate that. And I said at the start, they've kind of got some way along the way with it, but it still just does not compete with our SCSP structure, which now the SCSP, if you take a look at the corporate registry, if you take a look at the different fund launches here, all of the big managers are here, all of the big investors, the big insurance companies, etc. In particular, where you have a RAIF SCSP, you combine them or with the other partnerships and the RAIF. It's a tried and tested model. It's something that investors, managers feel comfortable with. So I think that Ireland has taken what's worked here to a degree. They haven't fully implemented some of the items that we have, but they've built something that it does have a place in the market. And I think the bigger managers, they have product everywhere anyway. So I don't think it's not going to be a case that we're going to lose out to some of them. I think they will just set up structures in Ireland to sit alongside their Luxembourg structures. But in terms of actually servicing it and setting up these structures, I think Ireland does have an alternatives industry. It is nowhere near on the scale of here. There's a lot of learning to do, I think, in Ireland still. I think some of the more technical areas that Ireland mightn't have competed with before, around carried interest and kind of waterfall calculations and things like that maybe weren't in play with Irish vehicles previously. I think there's some work potentially to do there. And I know that a lot of the big firms, they're in multiple locations, so they'll be able to learn off each other. But Luxembourg has seen everything, and I think if you look at what's happening in the alternatives world, it's getting more and more complex. Sebastiaan touched on the LTIF earlier on, and what's happening there in the alternative space and the complexities that will come with that. So these things in Ireland, they're a good few years behind, I think, where Luxembourg is in terms of that expertise, and I think there's going to be some way to go in catching up on that.
Just to add to that, I mentioned the consultation on the 1907 Limited Partnership, and there's a lot of submissions, and those submissions they do refer to Luxembourg, so they for sure are keeping an eye on what's happening here. They are learning from how the partnerships are working here in at least for the looking at changing the 1907 limited partnership.
Yeah, I think even if you turn back to, Christmas, Alfie produced different reports here on the growth in the different asset classes. I think debt funds were up, was it 36%? I think the amount of private equity funds over $1 billion in AUM had doubled. The number of them, like that's substantial growth, and that's substantial structures in both AUM and number of structures that are being set up here and that will continue to be set up here. And I think when that's tried and tested, Ireland, yes, they will kind of follow in Luxembourg's shadow, but I don't think, if we keep doing what we're doing right here in Luxembourg, I don't think we're kind of going to be dethroned. Not that it's that, not that we're trying to get too competitive, but I think Luxembourg will remain the leading domicile for alternatives.
Well, I think that the more structuring option we have, the more likely the investment manager are likely to come to Europe anyway. So it's always good to have one more tool in a more global toolbox than because at the end of the day, what matters is that the money comes to Europe and that the market here grows. Yeah, I think that's.
Yeah, no, look, I completely agree. I think if the concept is there that Europe is, because I suppose we have to remember that when we talk to US, UK, Asia managers, non-European managers, AFMD, it scares them and it's complex and they kind of don't understand why we have to do certain things. Depositories, for instance, different things like that. It doesn't fit into what they're used to with their Cayman Delaware structures, for instance, or Hong Kong limited partnership, different things like that. So I think the fact that there's now another option there, it makes Luxembourg seem, or it makes Europe as an alternatives domicile seem more flexible. And it's then, I said that it's about removing the hard barriers for Ireland to be a competitor. It does kind of remove the hard barriers from Europe and from what it is about setting up structures here, that now actually I have options and I can find something that works. And if it's the option between a manager not setting up in Europe or a manager setting up in Ireland but not Luxembourg, I don't think Luxembourg is going to be too disappointed if it's still money coming into Europe. Yeah,
definitely. And I think that the more it goes with time, the more the managers also get used to AFMD. They start to know that they have to play with these rules. First, we saw that they were all moving away from Europe when AFMD was adopted. Now they understand the rules and the concepts, so they come back. At least some competitors started to come back. So the big one, they decided also to come back as well, not to leave the place to other players. And I think they are now quite familiar, and we all see how the AIFM interact with a US GP, and how the AIFM can be introduced in the global structure when we have a big commingled fund. So yeah, and maybe Ireland and Luxembourg will be two different branches of the same commingled fund at the end of the day.
Yeah. I could well see it. We discussed earlier on double taxation treaties, and it's a well-known secret, or sorry, it's not an unknown secret that Ireland has a stronger double taxation treaty with the US, for instance, than Luxembourg. I know it's something I've heard that the Luxembourg ambassadors mention it before. It's something that they have on their radar, the US Luxembourg ambassadors to try tackle. But it might be a situation that you have a Luxembourg sleeve with an Irish sleeve, which acts maybe as some sort of a feeder master structure to allow you ultimately access that double taxation treaty into the US, and maybe that could be we go from kind of the two fighting siblings to the best friends. Maybe that's how this will play out. But I do think it could become a situation where there's enough here to share for everyone.
I think so. I think that's the conclusion.
I'm not sure that
there's a question.
No, there's a question.
It might just be, even before we jump on that, just to remind people that you can send questions in via the chatter, because it's something that people always don't do. So,
sorry, I'm getting older, but I cannot read it from here.
You mentioned that limited partners losses are limited to capital contributions. Are they also liable for unpaid capital commitments, such as debts to third-party lenders?
Okay, so for Luxembourg partnership structures, normally the liability of limited partner is limited to what they committed to contribute to the fund, not less, not more. So they will not be required to contribute more than their commitment. So if there are outstanding debt that cannot be met out of the assets of the partnership, the limited partner still have their liability limited once they have paid their commitment, and then that's the liability of the general partner, which has an unlimited liability, normally in order to secure this type of debt arrangements.
I mean, it's the same for the Irish partnerships. It's they're liable for the amount of that they've committed to contribute to the partnerships. And if that's pledged or whatever to a third party lender, then yes, they would be liable to pay it up to the amount of their capital commitment.
That's what we mentioned when we earlier when I described the structure of the special limited partnership. For instance, even though it does not have a limited liability, it is the legal personality. It is the entity that will be the contractual party. So it will appear as contractual party, and it will be the legal owner of all the asset, and it will be the legal entity responsible for all the claims against the partnership. So the limited partner, they are not even published, so no one can see who they are and what is the amount of their commitment as a principal, which ensure their limited liability. Another question.
Yes, what are the consequences if the LPA of a Luxembourg Scsp has not been signed into two originals?
It's shooting in your own feet.
Yeah, no, that's a very good question. So normally it has to be signed into originals. Yeah, the consequence is normally the partnership is null and void. So one should try to correct that if possible. Otherwise, we had recently the question regarding the execution by DocuSign, because DocuSign is it's an original. So execution by DocuSign may be fine because I mean it's there is only one signature, but there are as many originals as you wish. So probably that should work with one document signed by DocuSign. There are other practical issues with documents signed by DocuSign. In particular, if you want a legalization of the signatures, then it will be complicated to find notary that accept to legalize the signatures of a DocuSign signed document. So if it's DocuSign, that should be okay. If it's not DocuSign, then there is an issue there.
And if it's LuxTrust signatures?
I think that if you have if you have something that is really with a third party entity that can make sure that the document that has been signed has indeed been signed by the party that pretends to have signed it, and nothing can be changed, and with a trusted certificate, then that should be okay.
Yeah, I think we've been through the 1 hour exercise. If you have any additional remark, Sebastiaan, or I think we've covered pretty much the subject. It was intense, a lot of information, and I hope that in an hour you already have now a good overview of partnerships in Luxembourg and in Ireland. So thank you very much, our speakers, and thank you very much for this really interesting conference.
Thank you.
Thank you.